Greetings from New York. My name is Stefano Gennarini. I'm the Director for Legal Studies at the Center for Family and Human Rights. I'm very grateful to be invited to address you in this conference. I've been asked to speak to you a little bit about the international law aspects of anti-discrimination law and developments in recent years. And I would like to begin by noting the importance of anti-discrimination provisions in international law. International treaties, in particular the human rights treaties negotiated and adopted in the framework of the United Nations, establish a definite number of categories of non-discrimination. They list a definite number of categories, which are race, color, sex, language, religion, political or other opinion, national or social origin, property, birth. And these are the categories. They are not exclusive. The international human rights treaties also have a catch-all provision that other status should not be used to discriminate against individuals. The premise of these non-discrimination provisions, of course, is the Universal Declaration of Human Rights affirmation that all human beings share a common nature and dignity. And it is because of that this should not be discriminated against. However, in recent years, there's been debates on the use of terms like gender, sexual orientation, gender identity, and other categories in the context of non-discrimination discourse that raise questions. There have often been debates on the use of these terms. Sexual orientation, gender identity and these debates are often conducted on the assumption that these notions are clearly defined in science and law, but in fact, there is no scientific consensus on how to define these, and they are highly subjective and fluid categories. Very few countries treat individuals that identify as LGBT or lesbian, gay, bisexual, transgender, queer, intersex, etc. as a discrete class of persons, and many actually prescribe or prohibit homosexual conduct because of moral and public health concerns. Despite this, we see an increasing number of UN human rights mechanisms routinely put pressure on countries to adopt non-discrimination laws based on these notions or that include these notions of sexual orientation and gender identity as categories of non-discrimination. This is leading to increasing tensions between religious freedoms and the claims of advocates of these new rights based on individual sexual preference, subjective notions of gender identity. And so we have a real clash between, in the first instance, equality before the law, which applies to all human beings and all generally applicable laws. And in the second instance, we have special protections for certain categories of behavior and which are recognized in international law, specifically freedom of conscience and religion, freedom of having a political opinion, as well as things like the right to freely marry and found a family, which are clearly defined in international human rights instruments. As I said, the premise of international human rights law is that all human beings possess the same fundamental human rights by virtue of their inherent dignity and worth. This comes from the preamble of the Universal Declaration of Human Rights. Among these rights is the right to equal protection under the law without any discrimination. Individuals who identify as lesbian, gay, bisexual, transgender, queer, etc. are indeed protected from violence and discrimination in the same way as any individual under the equal protection principle in international human rights law. However, they are not entitled to special protections based on their sexual preferences and subjective gender identity as such. And so that is the distinction. The distinction is there are certain types of conduct and belief that have special protection in international law. But sexual preferences and subjective gender identity are not that kind of conduct. Sexual preferences and behaviors are not protected by international human rights law except in the context of the right of men and women to exercise their right to freely marry and to found a family. So the wide range of diverse laws regulating sexual mores, public health, marriage that exist in different countries, and the widely held understanding of the family as the natural fundamental group unit of society attest to this fact. So freedom of conscience and religion are among the highest principles of international human rights law. The International Covenant on Civil and Political Rights, for example, protects the freedom of thought, conscience, and religion absolutely, including with regards to the right of parents to teach their children such beliefs. It only allows limits on the right to manifest one's religion or beliefs, and then only when they are necessary to protect public safety, order, health, morals, or other fundamental rights and freedoms of others. But the notions of sexual orientation and gender identity themselves are not expressly addressed in international human rights law. They are not included in any negotiated international human rights treaty. To the extent that these notions exist subjectively in the conscience of individual, they cannot be regulated or curtailed if you look at the International Covenant on Civil and Political Rights, Article 18 specifically. But to the extent that they are manifested as behaviors externally, they are not especially protected as fundamental rights and freedoms under international human rights law. In the same way, for example, that freedom of religion or the right to freely marry and found a family, or the right to hold political opinions and manifest them, are expressly described and protected. Basic principles of legal interpretation require human rights to be interpreted as broadly as possible and oblige states to restrict human rights as little as possible and only for valid reasons. And this becomes very important when there is a clash between established human rights, including the rights of parents, the right to live your religion and to teach it to your children, compared with these new categories of rights based on these new categories of sexual orientation, gender identity, or gender more broadly. So if we apply an analysis based on international human rights law, specifically Article 18 of the International Covenant on Civil and Political Rights, we can say that any public manifestation of sexual orientation and gender identity may be curtailed by governments when it is necessary to protect public safety, order, health, morals, or the fundamental rights and freedoms of others. The fundamental rights and freedoms that must be protected in the broadest possible sense, however, in the context of the International Covenant on Civil and Political Rights, specifically Article 18, include the right to freedom of religion and belief, the right to freely marry and found a family, the right of parents to decide and direct the upbringing of their children, and the right of children to know and be cared for by their mother and father, the right of individuals to manifest their religious beliefs in their workplace and public life, and other fundamental rights and freedoms expressly recognized in international human rights law. So in the clash between subjective self-identification or behavior of any individual or group or individuals based on sexual orientation and gender identity on the one hand, and the manifestation of religious belief by an individual group on the other hand, it is the latter that must be protected because only the latter are expressly established in international human rights law as fundamental rights and freedoms. Moreover, as I already said, sexual preferences and behaviors are not protected in international human rights law outside of the right to freely marry and found a family. This leads to understanding how many of the acts that are by international organizations to promote sexual orientation and gender identity as categories of international law are highly controversial and even beyond their mandate. Over the last decade, the United Nations Secretariat, agencies, and UN human rights mechanisms have been advancing a controversial social agenda under the guise of promoting human rights for individuals that identify as lesbian, gay, bisexual, transgender, queer, intersex, or otherwise. Most recently, they are also promoting the notions of same-sex marriage and homosexual families as rights, even the right of homosexual couples to adopt and to purchase children through surrogacy. For example, there are many reports now throughout the human rights system and throughout the UN system showing how every UN agency is now working to promote this agenda throughout the UN system. Even the UN Children's Agency from already over a decade ago began promoting this agenda in a position paper on eliminating discrimination against children and parents based on sexual orientation and gender identity. They were making the case for giving legal recognition to same-sex families, decriminalizing sodomy, making the age of consent for sex the same for sodomy, and all of this was under the rubric of anti-discrimination law. Now that paper is still listed on the UNICEF website as a current issues paper. And since then, UNICEF, the UN Children's Agency, has only increased their promotion of these controversial issues. And the human rights bureaucracy has also been conducting multiple campaigns, including the Free and Equal campaign. There's also at the United Nations something called the LGBT Core Group, which is a group of states that promotes LGBT rights very aggressively in the context of the United Nations. And the UN agencies and other entities routinely issue statements, joint statements, to promote these issues. Now, these acts and declarations of the UN Secretariat and other UN entities are based for the most part on 9 binding recommendations of UN treaty bodies, special procedures, and other human rights mechanisms. Now, while they are not binding recommendations, a lot of these mechanisms like to say that these recommendations are authoritative. They even refer to them as jurisprudence sometimes, which is an ambiguous term because it could suggest binding precedent under the common law system. Now, this is highly confusing. On the whole, when dealing with these sexual orientation and gender identity claims, treaty body recommendations, UN Secretariat recommendations, UN agencies' publications contain unfounded and inaccurate assertions about the obligations of UN member states under international law. And many scholars have called into question even the authority of treaty bodies to issue such recommendations, so that they can't even be said to be authoritative. So any pressure on states based on these opinions is highly controversial and improper. Now, the main thrust of these recommendations is captured in 2 reports of the Office of the High Commissioner for Human Rights on violence and discrimination on the basis of sexual orientation and gender identity that were published around 2014 and 2015. And these reports say that international treaties require states to recognize homosexual relations and extend to them the same benefits reserved for marriage between a man and a woman, including parental rights, adoption rights, as well as to recognize transsexual sex change in law, and decriminalize any and all consensual sex between adults, including enacting special protections for individuals who identify as lesbian, gay, bisexual, transgender, queer, or intersex in criminal and employment laws and other law enforcement mechanisms, and to grant special asylum rights to individuals and their families when they identify as lesbian, gay, bisexual, transgender, queer, or intersex. And similarly, now this international framework having to do with sexual orientation and gender identity is not limited to non-discrimination. It infringes more and more on family law and freedom of religion. So, for example, the Office of the High Commissioner for Human Rights has also issued reports on the issue of the family for over 10 years, in which they try to create a space in international law for recognizing same-sex marriages and same-sex families within the definition of the family in international law. For example, they say things like there is no definition of the family in international human rights law, even though we understand very clearly that international law, and the text of international law is very clear about defining the family as the natural fundamental group unit of society, and also stating that it results when a man and a woman exercise the right to freely marry and found a family. Instead of continuing to endorse this understanding of international human rights law of the family as a basic holder of rights, the UN system has been saying that the family has to be understood in a wide sense, that there is no definition of the family. And the Office of the High Commissioner for Human Rights, which is the UN entity that services the UN human rights system and therefore gives legal advice to the entire UN system, says that the nuclear family, the extended family, other traditional and modern community-based arrangements are all equivalent under international law when it comes to caring for children. And obviously this is highly problematic because it undermines what international law says about the family. In fact, we can say that these acts and declarations of the UN Secretariat, treaty bodies, and other UN entities are ultra vires. They are beyond their mandate. They are illegal. They are not based on valid interpretation of international law, and as such, they cannot create any new legal obligations, either as interpretations of existing international instruments or by way of customary international law. This is consistent with the principle ex injuria jus non oritur, which is a very basic principle of law that says that law cannot arise from an offense against the law. So if you do something illegal, that illegal act cannot be the basis of international obligations. So in the context of the UN system promoting new obligations under the concepts of sexual orientation and gender, because these acts are not valid, they cannot give rise to any legal obligations. So this applies also to the purported existence of special rights based on sexual orientation and gender identity. And all human beings possess the same fundamental human rights, as we said, by virtue of their inherent dignity of worth. But sexual preferences and behavior are not protected by international human rights law. For example, like freedom of religion or political opinion. The only space international law recognizes for sexual autonomy is in the context of the right of men and women to freely marry and found a family. Debates on the use of the term sexual orientation and gender identity, as I said, are conducted on the assumption that these notions are defined in science and law, but there is no consensus about this. And we have seen this extensively in debates here in the United States. In fact, no UN human rights treaty includes the word sexual orientation and gender identity in any form, nor does the context and drafting history of the respective human rights treaties allow a good faith interpretation that includes special protections for sexual preferences and behavior in international human rights law. Unlike freedom of conscience and religion, sexual preferences are not protected under international human rights law. Quite aside from any moral considerations, there is no legal basis for asserting any special protections for sexual preference and behavior outside of the context of the right to freely marry and found a family, according to the definition of the family in international law as the natural and fundamental group unit of society. The right to privacy and family life similarly don't protect unfettered sexual autonomy. The Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights recognize a right to be free of interference in one's privacy and family life. But this cannot be understood to protect unfettered sexual autonomy or any kind of sexual activity between consenting adults. This is because at the time that these human rights instruments were negotiated and adopted by UN member states, many countries outlawed sodomy and nearly 80 countries still do so today. Many countries also restricted or penalized some form of sexual conduct between consenting adults or others, including incest, adultery, fornication, and many other countries still do today. Therefore, it is inconsistent to say that either the right to privacy or the prohibition against unjust discrimination in international law presume or can be interpreted as including protection of sexual preference and behavior outside of the context of the right to marry and found a family, as defined in international law. I would also like to, emphasize that also UN political consensus does not recognize these categories. So the UN General Assembly has repeatedly refused to include these notions in UN resolutions, and when they have been included, in the very rare occasions where Western countries, for the most part, force these concepts into UN resolutions, those resolutions have not been adopted by consensus, and countries have made strong reservations on the use of those terms. So for these reasons, I have to caution against any pressure from the UN system or other countries claiming that sexual orientation and gender, concepts like gender, require special anti-discrimination provisions in your domestic laws. Having said this about what international law says generally with regards to sexual orientation and gender identity, I think it's important also to talk about a couple of very important things with regards to the concept of gender. First and foremost, how the concept of gender doesn't really mean anymore discrimination against women. The term has evolved in international practice by international organizations, and therefore the term gender is highly insidious. And I would add that it is no more insidious than in the context of programming for gender-based violence. So I'd like to address that a little bit briefly, if I could. The term gender itself began to be used in the context of UN policy in the 1990s. Terms like gender, gender equality, gender balance, gender policies, gender sensitive, gender-based violence all began to be used to refer to the social, legal, and economic disparities between men and women and policies to address them. And UN member states accepted the term gender with the understanding that it referred to the two biological sexes and the promotion of the equality of men and women, nothing more. They thought that by using this term, they were focusing on the advancement of women and girls and addressing the equality of men and women under international law, as international treaties recognize. All UN treaties on human rights recognize the equality of men and women and prohibit discrimination on the basis of sex. But no international treaty even mentions the word gender until very recently. All the UN human rights treaties that were negotiated in the 20th century explicitly protect women by using the term equality of men and women and using the term prohibiting discrimination on the basis of sex. They do not use the term gender. But in recent years, this use of the term gender has acquired a host of new meanings and connotations, socially, legally, and in UN policy. In particular, the LGBTQI+, or lesbian, gay, bisexual, transgender, queer, intersex, etc., lobby groups, because they've been unable to gain their own political support in many countries, or to democratically carve out their own policy case, and funding, of course, they have found ways to piggyback on the hard-fought gains of the women's agenda. This definitions issue will briefly what we wanted to talk about now a little bit briefly is to talk about this debate about gender in the United Nations in recent years and draw out some of the implications for international law. So first, some remarks about the term gender itself. Gender is a grammatical attribute in many languages. Nouns have a gender and can either be masculine or feminine, or in some cases neutral. The pronouns and articles used in association with these nouns are of the same gender. The closest thing to this in the English language are the pronouns he and she. But sociologists and feminists, philosophers, professors began to promote the notion of gender as a social construct in the 1960s and 70s in academia in an attempt to overcome the social stereotypes about the role of men and women in society. So they started to say that gender is a social construct, that there's nothing essential about gender, or that gender is not related to sex in any way. So from the start, however, the use of the term gender in UN policy was therefore controversial. As I said before, there was no term gender in international law. So when in the 1990s this term started to appear in UN resolutions, it was very controversial. That's why at the 1995 Fourth World Conference on Women in Beijing, UN member states had to agree to a definition of the word gender before it could be streamlined throughout UN policy. And that definition was then reaffirmed again and again. And it continues to be used in the context of the United Nations. And the definition said this, which is very interesting. It said that the term gender had to be understood according to its common usage and understood in its ordinary, generally accepted usage in the context of the United Nations, which is already a stretch because, of course, it was a new term at the time. But it also said that there is no indication that this term should have any new meaning or connotation. So this is how the term gender came into UN policy. However, shortly after the 1995 conference, in the year 2000, or already before in the year 1998, when the Rome Statute of the International Criminal Court was negotiated and adopted in the context of the General Assembly, this was a binding international treaty that defined the term gender in a very clear way. Article 7 of the Rome Statute of the International Criminal Court defines gender as two sexes, male and female, in the context of society. And it further expresses that the term gender does not indicate any meaning different from the above. Well, this is very interesting because most of the gender agenda is not controversial. Most of the gender agenda would seem to be about the equality of men and women. And as countries agreed in Beijing, this has to do broadly with goals of including women's participation in social, economic, and political life, and ensuring that they are able to enjoy equal rights with men. But it should be noticed that the gender agenda builds largely, therefore, on the Convention on the Elimination of All Forms of Discrimination Against Women, where the term gender never appears. But here is what's happened. Over the last 30 years, since the 1995 conference in Beijing, when the term gender was first introduced in UN policy, the term gender has come to mean many new things. Increasingly, international aid agencies and UN agencies in particular include men who identify as gay, have sex with other men, or who self-identify as women in their international aid gender policies. You will find this across the documents prepared by the foreign aid establishment of most Western countries, most European countries, including the United States Agency for International Development until very recently, which defined gender as referring expressly also to concepts such as sexual orientation and gender identity. So, UN agencies have also adopted this variable definition of gender, and they justify streamlining LGBT issues into UN gender policy through mandates and UN resolutions to address multiple intersecting forms of discrimination. This is the term of art that they use. They use multiple intersecting forms of discrimination. Intersecting forms of discrimination ensure that LGBT categories can be introduced in all discrimination categories. They also try to include terms like women and all their diversity to refer to transgender identifying individuals. For the United Nations agencies, the ambiguity of these terms is enough to constitute a mandate to change the definition of gender agreed by UN member states in UN policy and in international law. The United Nations Development Program, for example, the largest and most important UN agencies overseeing billions of dollars in development assistance every year, has produced manuals on the Sustainable Development Goals and gender and sexual minorities, which links LGBT-specific programming to gender policy under the rubric of intersection of gender equality and sexual and gender minority issues. UN Women also promotes LGBTQ rights under the guise of promoting women's rights. So here is a UN agency created to advance the rights of women, and it has completely transmorphed to promoting the LGBTQI agenda. The UN Women Executive Director since 2019 announced that the agency would no longer be focused only on women's rights, but rather on the equality of all genders, including LGBTIQ+. At the event, in a special event titled Gender Diversity Beyond the Binary, the UN Women Executive Director made this announcement, and she said that the acronym LGBTQI+ was defined as referring to lesbian, bisexual, gay, transgender, questioning, or queer, intersex, pansexual, gender nonconforming, non-binary, and the full range of gender diversities that exist, quote unquote. And UN Women oversees a nearly $1 billion annual budget. This is very important to understand the nature of UN Women because it is a very powerful UN agency and it is very vocal in promoting anti-discrimination laws around the world because this is an agency that is solely dedicated to normative and lobbying activities, like training feminist activists and politicians abroad. So this is very interesting. This is a UN agency that all they do is lobbying internationally. They don't do traditional UN programming like delivering essential aid, healthcare to children in humanitarian emergencies. All they do is work at the normative level, that is changing policies, changing programs. And this drift away from focusing on women means that aid meant for lobbying related to women's issues is increasingly redirected away from women to lobbying for LGBTQI+ rights. Interestingly, the UN Women Director at the time admitted that there was no agreed mandate from the General Assembly to promote this broad notion of gender. But she said that her agency would push the envelope on these issues until equality of all genders becomes the norm, including overturning laws in all those nations that still do not allow homosexual sexual activity. More recently, along these same lines as UN agencies and donor agencies have been doing, the International Law Commission has produced a new treaty on crimes against humanity that is now being negotiated by the General Assembly. And this treaty discards the definition of gender in the Rome Statute that we just mentioned, that defines gender as referring to men and women, the two biological sexes and nothing more. So right now there's a real effort to redefine gender in international criminal law to establish a broad category of gender persecution. And the idea is that gender is now socially constructed. And the International Law Commission noted specifically the work of the prosecutor of the International Criminal Court, as well as the independent expert on the protection of individuals on the basis of sexual orientation and gender identities, as well as other UN reports, because they endorse gender as a socially constructed definition that includes sexual orientation and gender identity. So the interesting thing is that the legal effect of discarding the definition of gender in the Rome Statute will not be to leave the definition of gender to each country to define. Far from it. It will actually enshrine in international law an open definition of gender that can be interpreted for purposes of the crime of gender persecution as including any opposition to the LGBT agenda. So, for example, if you oppose adoption by homosexual couples, you could be labeled an international criminal if this international treaty on crimes against humanity is eventually adopted in the current format. And because crime of gender persecution is such a broad crime and does not require if the notion of gender is broadly defined and not limited to the discrimination against women, but also includes any kind of sexual orientation and gender identity issue, it includes a broad range of acts that can be considered crimes against humanity. And in fact, the ICC prosecutor has in his report on gender persecution, which is the publication that guides the International Criminal Court when it comes to prosecuting the crime of gender persecution, has specifically spoken about any restrictions on individuals' rights to form a family, presumably, obviously, including the individuals who are in same-sex unions. Any restriction or any advocacy against that can be considered a crime against humanity. So, changing a definition of gender to an open definition in UN policy and international law, and discarding the definition of gender, is clearly a door to as many different meanings of gender as there are individuals. And there's an ongoing open list of genders. We really don't even know how many genders there are. It includes novel genders like agender, androgen, androgynous, bigender, cis, cisgender, cisfemale, cismale, trans, etc., etc. This inevitably has implications for parental rights, medical ethics, the protection of the family. There are serious questions about the legitimacy of this project. Nevertheless, Facebook, a private company, not an international institution, not governed by norms of consensus, and the implications of importing this highly fluid, ill-defined notion of gender into international law are very serious. First and foremost, it undermines democracy. Most countries and their citizens do not consider gender a social construct, but a biological reality with legal implications. Through 2019, only 7 countries allowed legally recognizing gender change based on self-identification. There have only been a few more in a handful more since 2019, and this is according to the pro-LGBT group Amnesty International. And most of the nearly 40 countries where individuals are allowed to legally assume a transgender identity require a psychiatric determination of gender dysphoria or a surgical operation to mutate the sexual physiognomy of an individual. Some even require individuals to divorce their spouses and do not allow individuals with children to legally change their gender. The process the International Law Commission is proposing to make these changes in international law is very, therefore, democratically illegitimate. And all of these changes are being made under pressure from very powerful, well-funded lobby groups under very sort of untransparent circumstances. So the redefinition of gender to advance LGBT programs is a topic of controversy, even among feminist organizations. And many feminist organizations, including one that is quite famous called the Women's Liberation Front, are opposed to this. Their position is increasingly against hijacking the gender agenda to promote LGBT issues. Most recently, the UN Special Rapporteur on Violence Against Women, her name is Reem Al-Salem, has also spoken in favor of keeping international law protections based on sex, distinct from the concept of gender, because clearly the concept of gender does not have international consensus, whereas the concept of sex has a clear legal pedigree in international human rights law. Despite the political controversy around this issue, a focus on an open definition of gender is now pervasive in the UN system and beyond. It can even be gleaned by all UN reports. And UN member states need to decide whether or not this is what they want, or whether UN agencies will decide this for them. And so women are being erased from international law, international assistance, and international programs, and they're being pushed aside. UN member states should restore a proper understanding of the term gender in international aid and help preserve hard-won gains of women and girls. Member states should reject the new treaty on crimes against humanity, but they should also restore a proper understanding of gender more broadly in UN policy and programming. The United Nations should really avoid language in UN resolutions that allows ambiguity as to how the term gender is understood. And this also applies to individual states. It's very important to avoid duplicitous and ambiguous terminology. And it's also very important to refer to women as women, to violence against women as violence against women instead of gender-based violence. Because all of this will help protect women and protect their hard-fought gains against the encroachment of this controversial agenda. Just a final word on the concept of gender-based violence specifically, because gender-based violence is one of those issues that is most pervasive. For 3 decades, we've been hearing this term gender-based violence, but since it was first used, there are clearly several problems with the way it has been used. First of all, I would like to emphasize that the term gender, when applied to violence against women, becomes very problematic because the category of gender-based violence is a subjective category. It describes the motivation of the perpetrator of the violence instead of the objective state of the victim of violence. Focusing on the subjective state of mind of the perpetrators of violence introduces an almost impossible target for programs and policy. The term violence against women is objective. It focuses on the victim of violence. But gender-based violence has created an entirely new subjective category focusing on subjective state of mind of the perpetrators of violence, which is something difficult to verify or ascertain objectively. This also applies to the concept of discrimination. When you're talking about gender discrimination, you're talking about what is going on in the mind of the person discriminating. You are no longer talking about an objective state of fact. And using these subjective categories opens up international programming to social engineering goals, including promoting all aspects of Western radical feminism, including homosexual trans ideology and abortion extremism. Programs to address violence against women as an objective category have existed for decades, including objective and universal accepted strategies, targets, metrics, and other policy tools to end impunity for perpetrators of violence and provide victims of violence with social assistance and support. Programs to address gender-based violence, on the other hand, focus on changing the way entire populations think about men and women in the context of society, sexual mores, and other controversial social norms, including homosexual trans ideology and abortion extremism. This is by definition a form of social engineering. It runs counter to the spirit of international cooperation. UN agencies and donors use the categories of gender, gender-based violence, gender discrimination to promote homosexual and transgender issues, as we showed. They also use the notion of gender-based violence to promote abortion in international programs. For example, UN human rights officials have said that denial of access to abortion is a form of gender-based violence. And increasingly, they also use gender-based violence to implement censorship online, including through the governance of AI algorithms. And so we have seen this with the attempts to promote the concept of something called technology-facilitated gender-based violence or online violence, to limit freedom of speech, conscience, and religion, Progressive Western countries are pushing for global censorship through artificial intelligence to fight this technology-facilitated gender-based violence. This is a new term that can be used to recast opposition to abortion or any homosexual trans rights as a form of online violence to suppress them. So therefore also manipulating speech, manipulating political speech. This makes what many communist countries did in the 20th and 21st century seem like child's play. The possibilities of ramping up social control through artificial intelligence are multiplying. Therefore, that's why it's so important to avoid these controversial categories or categories that are ambiguous. So, just in conclusion, I would like to say a couple of words about the anti-discrimination law that is before you specifically. I would just, having glanced at it, at the translation of it in English, I haven't been able, obviously, I don't speak your language, but I'm able to glean a few things. That there has been a lot of concerns about religious freedom in the way it's been drafted. However, it does have terms like sexual orientation and gender identity, as well as gender, implemented in that treaty, and that is very problematic. Including, and it also refers to the UK Equality Act, which promotes the notion of gay adoption. There's nothing in the actual draft law legislation that promotes the parental rights in the context of decisions having to do with children. Maybe there are catch-all phrases having to do with other fundamental rights, but I would still be worried, given that there are the notions like sexual orientation and gender identity are expressly mentioned in that law, but protection of the family or parental rights is not expressly mentioned in that law. Moreover, I would also say that the idea of entrusting the entire framework of discrimination to a commission has a very threatening tone to me. The idea of creating a commissar or a commission to enforce this law is very problematic, in my opinion. And I'm not an expert on Taiwan's legal system by any stretch, but the idea of entrusting the enforcement of such a broad law with such controversial notions to a commission sort of harkens back to me to sort of the idea of a communist commission that analyzes all of the life of the country under this lens of gender discrimination and discrimination on sexual orientation and gender identity, and therefore has the potential for social engineering, not only because the commission has the authority to also act ex officio. Therefore, it is able to interfere in the political and social and economic life directly without ever having to have even litigants before it. So having said that, I want to thank you all for listening, and I remain open to any suggestions of if you want to contact me, if you have any questions, please do not hesitate. Thank you very much.